I think you have already apprised the participants that we are going to discuss today the subject captioned appreciation of evidence in criminal trials and criminal appeals. So far, we have covered in previous sessions subjects like framing of charges in criminal trials, discharge of accused persons, and perhaps one more subject that was bail or some other subject. This is third session during this endeavor which you people are undertaking to enlighten your participating members. For today, we are having for our discussions appreciation of evidence in criminal trials and criminal appeals. You know, from July 1st, 2024, we are now having a new legislation on the law of evidence. Bhartiya Sakshya Adhiniyam 2023. It has replaced that British era old legislation which we people so far knew as Indian Evidence Act 1872. If you compare these two legislations, one that of British era of 1872 and the recent legislation which our parliament gave to the country in 2023, Bhartiya Sakshya Adhiniyam, you will find that there is only very little, or you can say very insignificant change in these two legislations. As regards the Bharatiya Nagarik Suraksha Samhita 2023, the Indian Penal Code that has been replaced by Bharatiya Nyaya Samhita 2023. There are major changes. Many provisions have been changed, amended, and newly inserted. But as regards Indian Evidence Act, which is now Bhartiya Sakshya Adhiniyam, there is very little change. There is no drastic change, no major changes introduced in this new legislation. All the major provisions of the old Act of 1872, Indian Evidence Act, are very much there in this new legislation of 2023. So our approach to understand the provisions of this new Bhartiya Sakshya Adhiniyam would be the same, which we used to apply so far in relation to the outgone old legislation, Indian Evidence Act 1872. And therefore, when there are no fundamental changes in this new Bhartiya Sakshya Adhiniyam as compared to 1872 Indian Evidence Act, then the Supreme Court rulings which we are using so far to interpret, to understand the correct meaning of the provisions, that will continue to apply to this new legislation. In today's exercise, we will take help of leading Supreme Court decisions. As you are familiar that we always understood any concept, any provision, its true meaning only with the help of the leading Supreme Court decisions. And this time again in this session, we will be doing the same exercise. I so far made you known to the applicability of the new legislation and the old legislation. I will draw your attention to a particular section of this Bhartiya Sakshya Adhiniyam. The last section of this Adhiniyam, section 170. In Indian Evidence Act, we were having 167 sections. In Bhartiya Sakshya Adhiniyam, there is addition of 3 sections, and as such, we are having in Bhartiya Sakshya Adhiniyam 170 sections. The last section 170 says the old act, Indian Evidence Act of 1872, will continue to apply to all those cases which were pending in the courts prior to enforcement of this newly enacted Bhartiya Sakshya Adhiniyam. It means all those cases which were pending in the courts up to June 30, 2024. Evidence Act of 1872 will continue to apply to them. But those cases which are instituted on July 1st, those applications, those trials, those proceedings which were for the first time instituted in the courts on July 1st, they will be covered by this new legislation, what we now know as Bhartiya Sakshya Adhiniyam 2023. So let you be first very clear in your minds that in old cases or in all those cases which were already pending in the courts up to June 30, they will be covered by the repealed law. What is that repealed law? Indian Evidence Act 1872. And those cases which came to the courts for the first time on July 1st and onward, they will be covered, they will be dealt with by this new law, Bhartiya Sakshya Adhiniyam 2023. So I think you people are clear where old Evidence Act will apply and where this new legislation, Bhartiya Sakshya Adhiniyam 2023 will apply. We have to deal with today with the provisions of both the legislations, the outgone Indian Evidence Act and this new Bhartiya Sakshya Adhiniyam. I pointed out to you earlier that there are no drastic changes in this new law, Bhartiya Sakshya Adhiniyam. Only cosmetic changes have been made which do not substantively affect the applicability of any of the provisions of the outgone Indian Evidence Act. It is always safe to apply the Supreme Court rulings, the rulings rendered by various high courts on the old act, outgone act, Indian Evidence Act. You know, the law of precedents, the law of rulings. It says, as clarified by the Supreme Court in many cases, that if the provisions in two legislations are analogous, are identical, then law laid down by the court of records on any one of them can be safely applied to the others, provided the fact position permits. So, legal position is that the law which was so far declared by the Supreme Court on Indian Evidence Act 1872, they can be very much applied to this new Bhartiya Sakshya Adhiniyam. There is no English version of this Bhartiya Sakshya Adhiniyam. There is some problem in pronouncing it, in reciting it and quoting it. But given the legislative wisdom of the parliament, they thought it better that no English nomenclature would be given to Bhartiya Sakshya Adhiniyam. Henceforth, you will have to pronounce and to cite and write only Bhartiya Sakshya Adhiniyam, not Indian Evidence Act, if the case is covered by Bhartiya Sakshya Adhiniyam. But in those cases where that old law, Indian Evidence Act, is applicable, you can cite, you can write Indian Evidence Act. But those cases which for the first time came on the docket of courts on July 1st, you cannot cite Indian Evidence Act. You will have to write Bhartiya Sakshya Adhiniyam. With this initial introductory words, I invite your attention to how criminal cases are decided, how the evidence in criminal cases is appreciated, evaluated, how the findings are derived from the evidence brought on record of the criminal cases. You know, there are different types of evidence which are brought on record on a criminal trial. What are those evidences? If you go to the very provisions of Section 3 of the Indian Evidence Act of 1872, it defines and provides the kinds of evidence. This outgone Indian Evidence Act says evidence is of these types. One is oral evidence, then documentary evidence, electronic records, tangible objects. But Section 3 of the Evidence Act nowhere provides for tangible objects, tangible things. It provides basically for two types of evidence, oral and documentary. And in the definition of documentary evidence, it has included electronic records also. You know, in the year 2000, Parliament amended the Information Technology Act 2000. And in the same very year, in 2000, Parliament also amended many sections of the Indian Evidence Act. And in the form of additional sections like 65A, 68A were inserted in the Evidence Act in order to give effect to the provisions relating to the electronic evidence. What are electronic evidences? What are the sources? You know, any electronic gadget like computer, like CCTV device, camera, like mobile phones, mails, and in whatever form, soft form, the evidence is available in a hard form electronic device. It has been recognized from the year 2000 in Evidence Act of 1872 as electronic evidence. But they have not been given a different category, a new category. Words electronic evidence have been included in documentary evidence. So you can say that the outgone Evidence Act recognizes only two types of evidences. One, oral evidence, other, documentary evidence, including electronic records. But this definition is not complete. The Supreme Court has recognized over the decades two additional types of evidence to be admissible in criminal trials, in criminal appeals, besides those two which Section 3 provides and defines. So what are these two additional types of evidences which the Supreme Court has recognized? They are tangible objects. And how can electronic record be included in document? Document, you know, most of the time they are in the paper form. They are not in soft form. But when a message is passed from one mobile to other mobile, when a photograph is recorded by CCTV camera or sub camera or by mobile, then it is always available only in the soft form in the electronic device, in the mobile, in the camera, in the CCTV. It is not in hard form. The metal, the device which has been used, the metal which has been used in manufacturing the electronic device. That is in hard form, but that's not the evidence. The contents, the photographs which are available there in the soft form, they are the only evidence. Therefore, Supreme Court has rightly clarified the evidence is of four types. One is oral evidence. Number two, documentary evidence. Number three, electronic evidence. And number four, tangible objects. Stakes, bamboos, bombs, gases, poisons, liquid, stones, knife are used. All these are the means which are used in committing the crimes, the offenses. And these evidences are quite important pieces of evidence which are collected by the police during the course of investigation, which are produced in the courts, which are provided for to be accepted in the courts. So they are also very much admissible piece of evidence. Oral evidence, documentary evidence, electronic evidence, evidences in tangible forms. These are four categories of evidences which are brought before the courts in a criminal trial. Not necessarily all the four types of evidences are always produced in a particular case. Sometimes there are two types of only oral and documentary evidences. Sometimes there is electronic evidence also, and sometimes there is this fourth category evidence, which is the electronic object, the stick that was used in causing the injury, the knife that was used by the accused in committing the offense, the gases, the poisons, liquid, or what in whatever form, whatever means, whatever thing was used in committing the offense, everything is then a piece of evidence and it is produced before courts. In a criminal trial, we have to deal with oral evidence, documentary evidence, electronic evidence, tangible evidence. These four types of evidences are used in a criminal trial. In our discussion today, we will take up this first category evidence, the oral evidence. What are the sources of oral evidence? Who provides the oral evidence to the courts? You know, the witnesses. The source of oral evidence are the witnesses. They come to the court, they are examined in chief, then they are cross-examined by the other side. Their depositions are recorded, the statements are recorded, what is called as oral evidence. We will be dealing today with oral evidence, and the source of oral evidence are the witnesses. The arranged people are already familiar with my website, lawhelpline.in. Those who have for the first time joined this exercise today, they may note down. Otherwise, all other participants are already familiar with the name of my website. Small letters without any space, lawhelpline.in. All the contents of this talk which I am delivering to you are very much available on that website. There are more than 200 subjects, files. One of them is this one, appreciation of evidence in criminal trials and criminal appeals. You can access this on my website and have it in front of you on your mobile, on your computer. I am inviting your attention to point 1.4 of my write-up available on my website, lawhelpline.in. 1.4. Kinds of witnesses. I was just telling you, courts have to deal with oral evidence in a criminal trial. And the source of oral evidence are the witnesses. What are the sources of oral evidence? Witnesses. How many types of witnesses do come to our court? If people are practicing advocates, every day you see that the court campus is full of litigants, parties belonging to the cases, and then these witnesses, hundreds of witnesses come to the courts every day. So what if you categorize the witnesses, if you give the nomenclature to different types of witnesses which come to the court campus to depose either in support of the case of the prosecution or in support of the defense version of the accused, you can find this is the category of witnesses. These are the names of witnesses which do come to our court system, to our court campus, to our courts. I am just pointing it out to you. What are the names of different types of witnesses which are examined in the criminal courts in order to record their deposition? Number one, independent witness, then direct witness. Direct witness means ocular witness, a witness who had seen the incident occurring, in whose presence, whose audio visibility the occurrence had taken place. He is called eyewitness. Independent witness, eyewitness, interested witness, family member as witness, relatives as witness. I'm citing it from my website. You can open my website and read it with me. Friendly witness, inimical witness, hostile witness. Badao bhai thoda sa. Inimical witness, hostile witness, injured witness, sterling witness. Sterling means important, necessary, reliable, credible. A witness who is trustworthy. Supreme Court has given him a name in 2020 in Santosh Prasad versus State of Bihar. 2020, volume 3, Supreme Court cases, page 443. In short, you can note down this case, Santosh Prasad versus State of Bihar, 2020, 3 SCC 443. In this case, Supreme Court has given a name to this type of witness. Supreme Court says if a witness is fully credible, reliable, dependable in the assessment of court, in the opinion of the court, then this witness can be called to be sterling witness, necessary witness, most credible witness, excellent witness, you can say. Then there are chance witnesses, child witnesses. A child is also a competent witness. Section 118 of the Evidence Act. Deaf and dumb witness, tutored witness, habitual witness, hearsay witness, planted witness, police personnel as witnesses. Among the police personnel who come to the court as witnesses, investigating officer is there, the constable who had recorded the FIR, who had, if verbal information was furnished to the SHO, the constable who was sitting at the police station, he recorded the evidence, recorded the FIR. He is called chief FIR recording witness. Then there are number of official witnesses, a medical practitioner in some government hospital, these police officers, police personnel who come to the court, any person who is a government servant, a public servant, they are called to be public officers, official witnesses. When they come to the court, their category is official, a police officer, executive officer, a medical officer belonging to government hospitals. They are government servants, public officers. Therefore, they are categorized as official. Then there are expert witnesses. You know, there are experts of many subjects who on some point of time come to the courts in support of their opinion, which they had furnished to the court earlier. They are recognized as medical experts or medical doctors, handwriting experts, thumb impression and fingerprint experts, typewriter expert, voice expert, chemical examiner as expert, ballistic expert. Then, you know, science and technology is a very vast subject. Beyond these types of expert witnesses, which I just enumerated to you, there might be some other expert witnesses also belonging to some other field also. Suppose a nuclear scientist, a space scientist, they are expert of their field. If there is a case wherein their deposition is necessary, their evidence is necessary, then they may also be examined in the courts as expert of their respective fields. So there is a long list of experts belonging to these different fields of expertise. Then secondary witnesses. If the primary witness is not available, then a substitute is produced as witness and he is called secondary witness. Suppose Mr. X had executed a bill deed, but he has died. His signature has to be proved. So either the witnesses in whose presence he had put his signature upon the bill deed, they will be called as attesting witnesses to prove the bill deed. Otherwise, those people, suppose the witnesses are also not available, they are traceless, or they are already dead, they are not alive, to come to the court and depose and to prove that Mr. X had put his signature in their presence on the bill deed. Then those persons who, though were not present at the time when Mr. X was putting his signature on the bill deed, but they were familiar with the pattern of writing of Mr. X. They were familiar with the manner of putting the signature, or familiar with the type of signature which Mr. X used to put on papers with his writing, with his signature. They may be examined before the court as secondary witnesses, as substitute witnesses. So when the witness who was maker of the document, or in whose presence the things had occurred, who had actually seen the things happening in the manner described in the documents, they are not available, then secondary witnesses are called in place of primary witnesses. So this is the list of different types of witnesses. Secondary witness, approver as witness. You know, sometimes co-accused deposes against the other co-accused, or sometimes one of the accused turns to be a witness for the police, for the prosecution, and then he supports the prosecution case and he is pardoned for helping and they are called approver as witness. Accused as witness. In outgone CRPC under section 315, analogous section might be different in this new Bhartiya Sakshya Adhiniyam. Accused can also examine himself as defense witness, can request the court to be permitted to be examined as defense witness, and then court would record his statement, his oral statement, his deposition, and that will be read, evaluated by the court. There is this long list of different types of witnesses which do come in the courts, and I pointed it out to you from my website. I'm again reading out different types of witnesses are back. I'm just reading out for you again. Independent witness, direct witness, interested witness, family member as witness, relative as witness, friendly witness, inimical witness, hostile witness, injured witness, sterling witness, chance witness, child witness, deaf and dumb witness, tutored witness, habitual witness, hearsay witness, planted witness, police personnel as witness, chief FIR recording constable as witness, witness to arrest and recovery, official witnesses, doctors, medical practitioners as witnesses, and writing expert, thumb writing expert, thumb impression expert, fingerprint expert, typewriter expert, voice expert, chemical examiner, ballistic expert, secondary witness, approver as witness, accused as. I leave it for you to enumerate and you find for yourself the exact number of witnesses which come to the courts and whose oral evidence is recorded when they are examined. I just pointed it out to you to be familiar. These are different types of, I think they are perhaps 36 or 38. And Evidence Act, this Bhartiya Sakshya Adhiniyam, nowhere provides in any section this category, this list of different types of witnesses. Then where from you will have to be familiar with these witnesses from the Supreme Court decisions, from practice. You know, the Evidence Act is a practical subject, is a law which is put into practice in courts. It is practically applied, judicially applied in given set of facts and cases. And therefrom, this list has been taken by me. And basically, the source is the Supreme Court decision. Before proceeding further, I will remind you of two articles in the Constitution of India. Article 141, 144. What do they say? 141 say? 141 says, the law declared by the Supreme Court of India shall be binding upon all. And what is 144? It says, all the civil and judicial authorities within the territory of India shall act in aid of the Supreme. These two articles in the Constitution together provide that if a law is declared by Supreme Court in its judgment, then that law becomes binding upon all courts, on all authorities. All courts will have then to act in accordance with that law only. And when there is a difference in between the legislative provision enacted by the legislature and the interpreted law by the Supreme Court in its judgment, I have already told you it is the interpreted law of the Supreme Court in its judgment that will be ultimate, that will be the final law, not the law enacted by the legislature as contained in their provision. When a particular provision of law enacted by legislature is interpreted by Supreme Court in a particular manner, then there is no choice except to apply, except to follow that interpreted law as given by the Supreme Court in its judgments. So ultimate law comes from Supreme Court, the interpreted law. Why it is so? Because it is the scheme of the Constitution of India. Article 141, Article 144 provides so. And you know, the Constitution is the supreme law. Any other subordinate legislation, subordinate law, which is repugnant, which is contrary to the provisions of the Constitution, which is in conflict, in clash with the provisions of the Constitution, that will not be applied. That will be ultra vires, that will be ignored. And the law given by the Supreme Court will be given precedence, primacy. That will be. Whenever you find there appears to be some conflict in between the interpreted law of the Supreme Court and the legislative law given by the legislature, you will have to go by the law given by the Supreme Court, interpreted by the Supreme Court, because this is the mandate of Article 141 of the Constitution of India. I was just drawing your attention to different types of witnesses which are examined in a criminal trial. Suppose they are 38 in number. If you categorize them based upon their credibility, their reliability, so these 38 types of witnesses then come into these three categories. Either a witness would be wholly reliable, or wholly unreliable, or partly reliable and partly unreliable. There can be no fourth category of a witness as regards his or her credibility. A witness examined before the court may be either fully reliable, absolutely reliable, or absolutely unreliable. And then third category might be, in part witness might have deposed truth, and in part witness might have deposed untruth. He might have lied on certain facts, and on certain facts, other facts, he might have told to the court a true version. This third category is the most important category. Almost all the witnesses who come to the courts, they speak truth on some issues and speak untruths on some other issues. The deposition of witnesses in our court system is always a mixture of truths and untruths, satya and asatya, a mix of truth and untruth. This third category is most important category. There is no reason to say that absolutely reliable witnesses do not come to the courts. in a large number, witnesses are declared to be absolutely reliable, fully reliable by the courts, and their testimony is acted upon, and then convictions are recorded. And in good numbers, witnesses are declared to be untrustworthy, unreliable, incredible, and then their testimony is rejected. Then this third category, which calls upon the judge to apply his knowledge, his skill, his experience in separating the truth from untruth. This third category witness is the most troublesome witness for the judges. When the witness is fully reliable, task of the judge becomes easier. When the witness is fully unreliable, then again the task of the judge becomes quite easy. But when this third category witness comes to the court, who is neither fully reliable nor fully unreliable, but he has told to the court truths as well as untruths, a mixture of truths and untruths, then here the judge is called upon to apply his skill, his knowledge, his experience, his understanding, his wisdom to separate the falsity from the truth into the deposition of. I will now deal with oral evidence of a witness who claims to be an eyewitness to some incident, who is a prosecution witness whom the police has shown in the FIR, in the charge sheet, to be the eyewitness. He has come to the court and he has made a statement in support of the prosecution case. So what formula you will apply in judging, in assessing, in recording a finding as judge, whether the witness should be declared to be reliable, to be unreliable, to be partly reliable or partly unreliable. Now I will deal with this part of exercise today. Reliability of, I am taking here the oral evidence of a witness who claims to be an eyewitness to an incident. He has come to the court, he has been examined in chief, he has been cross-examined by the defense, and his deposition running into numbers of pages is available on the record of a criminal trial. This might be interesting for you. You keep with me, you keep attentive with me and try to understand how the credibility of a witness is judged by judges, by courts. I again repeat for you, any witness is bound to fall any of these three categories in courts. One is wholly reliable, fully reliable. Other is wholly unreliable, fully unreliable. And third one is only partly reliable. I have given a number of Supreme Court cases for your understanding on this issue. I am taking up point number 2.2 of this write-up. If you have opened your laptop, your mobile, and you are here with me in this exercise by opening your mobile or this electronic device, what is called this computer, I am taking you to point number 2. Mode of appreciation of testimony of an eyewitness. If you have gone to the court, and most of you people are practicing lawyers, I am making this statement for students, senior students who are participating in this session. There are their purposes I am pointing out. If they have not gone to the courts, they have hardly any idea how the witnesses are first examined in chief and then they are cross-examined by the defense side. But for lawyers, they are very much familiar. Every day they do the same thing in the court. They know. Students don't know. So for them, I am telling you, when an eyewitness is examined in the court and his deposition, his gawahi is recorded, so what should be the approach of the court, of the judge, of the magistrate to evaluate the quality of testimony of that witness? What are the formulas which are applied in testing the credibility of the witnesses? I am drawing your attention to this with the help of Supreme Court decisions. Firstly, it should be seen if a witness claims to be an eyewitness to the court, to some incident, and comes to the court and makes his statement, his deposition is recorded. So duty of the court is to see, first of all, whether the claim of this witness is true, that he was present on the spot when the incident took place. If the prosecution has examined a witness as eyewitness, then duty of the court is, first duty of the court is to record a finding by evaluating the evidence of that witness, whether a finding comes out from the deposition of the witness that he was present and in his presence the crime was committed and he had seen it. First finding should be recorded by the court out of the deposition of an eyewitness on his presence on the spot when the incident had taken place. And then number 2, despite being present on the spot, whether the witness had actually seen the incident. Suppose it was an incident that occurred in night. There was no source of light. There was complete darkness. Somebody fired at someone, and a witness comes to the court and deposes that I had seen the incident. Accused X had fired at injured Y. Question arises: how should the court judge? Court form its opinion. Court should record its finding. Whether this witness has told truth to the court or has told untruth. Whether his claim to be present on the spot is true or false. Formula is: normally if a witness says to be present on the spot when the incident took place and there is no contrary evidence brought on record to discredit the witness, then principle is unless otherwise is proved, it has to be presumed that every man tells the truth. I am again repeating this general formula. If no otherwise evidence is brought on record to discredit the witness or to discredit a person, then normally it will be presumed that that person or that witness had told the truth. जब तक कोई otherwise साक्ष्य ना आए, यह माना जाएगा कि जो कुछ भी साक्षी बोल के गया है वो सत्य है, ट्रू है. तो courts always start with the presumption of truthfulness about the witness unless the contrary is proved. It doesn't mean कि whatever the witness has told to the court, whatever oral evidence has been recorded, it will be taken to be true only. No, not at all. Normally the court will start with this outlook, with this approach, that the witness has told truth. There is no presumption. If there is any infirmity, weakness, laches in the deposition of the witness which leads the court to form an opinion, no, because of many self-contradictory statements, because of other pieces of evidences, contrary pieces of evidences brought on record, this witness was not, it is proved that this witness was not present on this spot when the incident took place. And court won't believe this witness, will reject. No presumption will work with the court to believe the witness. Then normally these three things are seen in the deposition of a witness: his presence on the spot, number one. Number two, whether despite being present, he was able to see the incident. Suppose somebody suffers from poor eyesight and he was at a distance of 200 meters and he was unable to see the assailant, see the injured or the manner of occurrence. Then despite being present somewhere around the place of occurrence, his deposition would not help the court. He will be normally disbelieved unless he is supported by any other supporting piece of evidence, what is called corroboration theory, by some other bit. Otherwise, normally witnesses are believed. There is no otherwise any disabling evidence on record. I am now pointing out those principles which are applied in judging the testimony of a witness, whether the witness has told truth or untruth. Here are 4 words in front of you in my write-up. I am pointing out point number 2.4, para number 2.4. Exaggerations, inconsistencies, embellishments. These are certain principles, formulas, methods devised by Supreme Court in number of judgments over the decades. Supreme Court says in order to judge the credibility of a witness, in order to declare a witness to be true or false, true or untrue, his testimony, whether his testimony should be accepted or not, court should apply these formulas. Court should carefully read oral evidence given by the witness and should see these things in his deposition. Contradict. What are contradictions? If a person tells two contrary things on the same fact, same point, same issue, at one place he says the occurrence had taken place in such and such manner in his deposition. In some other paragraph, at some other place, he says, occurrence had taken place in a different manner. So when a person makes two contrary statements on the same very fact, then a contradiction appears into his state, into his deposition. And this is a normal feature which every day happens in the depositions of witnesses. Whether a witness is intelligent or a stupid one, it doesn't make any difference. Witnesses are bound to make contrary statements, self-contradictory statements in their depositions, because nobody is free from the weaknesses of human nature. The Supreme Court says when the witnesses are examined after lapse, after many years, in our system, the eyewitnesses come to the court, trial starts after many months, after many years, and with the passage of time, the human memory fades. So nobody can then give a videographic account of the happening to the court. A witness is bound to commit some mistakes in telling to the court as regards the description of occurrence, who assailed, who got injuries, and what happened exactly on the spot at the time of incident. It becomes then very difficult for anyone when there is huge lapse of time in between the deposition and the date of occurrence. So Supreme Court says that some contradictions are okay. It doesn't mean simply because the witness has made some contradictory statement, and it should be seen by court whether the contradiction is normal, natural, minor, or contradictory statement. Normal, natural, they do not corrode his credibility. They do not go to the root of his reliability, trustworthiness. So despite there being certain contradictory statements on same very fact in the deposition of the witness, he has to be believed by the court, because appearance of certain contradictions are quite natural. They are not unnatural, but it must not be serious contradictions and major contradictions. Minor contradictions are there, they are okay. But when there are serious and major contradictions, they will be taken seriously by the court. And then court will disbelieve that witness on that fact. It doesn't mean on a particular fact simply because witness came to depose before the court on 10 points, and on 1 or 2 points witness has made contradictory statement, and on all other points, remaining 8 points, he has correctly narrated the manner of occurrence and has supported the prosecution story. Then it doesn't mean for 2 mistakes or 2 contradictory points, the testimony of the witness as a whole would be rejected. No, I will point out to you that there is a principle, a theory, falsus in uno, falsus in omni. I will describe it for you later on. It means ki false in one, false in all. This is a principle, a doctrine, a proverb, legal proverb, prevalent in England. It's not applied in India. If a witness has lied on one fact, it doesn't mean he has to be disbelieved on all other remaining facts told by. If the court is of the view that on a particular fact witness has lied, he will be disbelieved on that point only. For the remaining facts, he will be believed, partly reliable and partly unreliable. The category which I had earlier pointed out. I am just dealing with in every witness's deposition, evidence, oral evidence, these things do appear. There can be no witness in this world in whose deposition, in whose oral evidence, these things do not appear. Contradictions, inconsistent statements, exaggeration, embellishments. They are bound to appear. Duty of the court is to see if they are only minor in nature, it should be ignored. If they are major, serious, which reflects upon the credibility of the witness, then contradictions should be taken seriously and witness should be disbelieved. Otherwise, minor contradictions, Supreme Court says, if there are minor contradictions in the statement, the oral evidence of a witness, it guarantees, it acts as a guarantee that the witness was not tutored, and the passage of time, his memory had headed, therefore he erred somewhere, sometimes on this fact or sometime on that fact. That's quite natural. And when a witness quite naturally deposes to the court, his testimony cannot be disbelieved. If there are no contradictions at all in the deposition of a witness, then the court should be a little cautious. How it happened? This person did not commit even a worse mistake in describing the manner of occurrence, despite the fact that he was examined before the court after several months, after several years of the incident. So when there are no contradictions, then court should be cautious. Why this witness should be believed? Photographic account, audio, video type account can't be produced by the witnesses before the court. It's impossible for anyone. It's humanly not possible. When the time elapses, people commit mistakes in describing anything. So is here in respect of the oral evidence of the witness. Contradictions, major and minor. 2 types of contradictions are there, minor and major. How can a lawyer, a judge, identify whether a particular contradiction having appeared in the oral evidence of a witness is minor or major? Is a minor contradiction as a major? What are major contradictions and what are minor contradiction? What are the symptoms, identity? If this is not clear, then everything is only theoretical. And law in our courts is applied judicially, practically, and very little theoretically. All the theoretical law, when it reaches the court system, whether it is trial court or appellate court, then theoretical law gets converted into law in practice, judicial law, a law which is applied judicially to the given facts, to the cases. And that skill you need, that experience, that knowledge is required in court, to the lawyers, to the magistrates and judges. Not that theoretical law that was taught to we people in classrooms, in law colleges, in departments of law in university. That helps us only passing out our LLB 3 years, 5 years, and getting a certificate, a degree, and then going to the bar council or appearing for judicial services, getting engaged with our profession. So law is applied in courts, in criminal trials, judicially. So this is the judicial application of law. Your Evidence Act of 1872, your this Bhartiya Sakshya Adhiniyam 2023, this new piece of legislation, it nowhere provides how will you evaluate the testimony of a witness. It is from the Supreme Court judgments. These formulas, these methods, devices have come to us over the decades from hundreds and hundreds of Supreme Court judgments. Contradictions, if it is major, then witness has to be disbelieved, and if it is minor, then it has to be disbelieved. For example, I am giving you example to understand how minor or major contradictions are identified. Suppose that some 5 years back, on January 20, an incident had taken place. A witness who came to the court after 5 years to give his oral evidence in support of the prosecution case, he was subjected to cross-examination by the counsel for defense. During cross-examination, witness says, a question was put to the witness, what was the date, what was the day, whether it was Sunday or Monday, and what was the date when the incident had occurred in the year 2019. In FIR, the date is 19th January, 20th January 2019, some 5-6 years back. The witness says that perhaps it was 27th January. The exact day was Sunday, and the witness deposited before the court, perhaps it was Friday. Here, witness, during the course of his cross-examination before the court, has erred on 2 counts. He has incorrectly told to the court the date of occurrence. He has incorrectly told to the court the day. He was not able to correctly because it is humanly impossible. Many people do not remember, do not know even their date of birth, the dates of birth of their children. Why and how can they remember a date of some unpleasant incident? Then they do guesswork. Oh, perhaps it was winter season and it was perhaps 27th or 15th. They may err in terms of date, in terms of day, timing, weather. If they are giving a mistaken account on all these things, these are minor content. But if they are making mistakes in telling to the court regarding the nature of weapon used by the assailants against the injured person, or with regard to their presence on the spot when the incident had taken place, then contradiction is not minor, it's major. I'm giving you example to identify a major contradiction. Having appeared in the deposition of an FIR was lodged against the accused persons that they had fired at the deceased, and as a result of gunshot injuries, the deceased had died. Postmortem report also says the cause of death was firearm injury. This is FIR, this is postmortem report. Medical witness comes to the court, claims to be an eyewitness, and says the accused persons had assaulted on the deceased with axe, with swords, with knives. And I had seen them holding knives, swords, and axe into their hands. And they had killed the deceased by causing him injuries with these weapons. Can this witness be believed? When the FIR version, prosecution version is the accused had used firearm injuries. Postmortem report supports that story. Yes, deceased had died because of firearm injuries, but the witness says no, sword was used in causing the injury, and as a result of sword injuries, he had died. It means this witness was not present on the spot. Had he been there on the spot, he must have seen the weapons which the accused persons were carrying into their hands. When such a contradiction has appeared in the deposition of a witness, he has to be dismissed. Suppose that this witness, during the course of investigation of the offense, when the investigating officer had gone to him to record his statement under section 161, he had made a statement to the IO during investigation that I was present on the spot. In my presence, incident had taken place. Accused persons had fired at the deceased, and he had died as a result of bullet injuries. This is the statement made by this witness during investigation to the IO under section 161 of the CRPC. And before court, when he appeared to make his oral statement, give oral evidence, he says no, accused persons were holding swords in their hands, and I had seen them carrying swords, and they had assaulted with the swords, the knife upon the deceased, and he had died as a result of sharp injuries. Is this contradiction in these two statements, which he had once made earlier during investigation to the IO under 161, and later in time which he made before the court? They are drastically opposite to each other, contrary to each other, and they are not minor in nature. With reference to his former statement made to the IO under 161, he is directly hit he directly stands discredited. This witness on this count is not at all believable. And an inference, a finding would be derived. If the witness had been there on the spot at the time of occurrence, he must have seen the incident. But he has not been able to correctly tell to the court about the weapons used by the accused person because he was not there. He had seen nothing. At one point of time, 5 years back, he had told that firearm injury was used, but he has now contradicted himself. He is belying himself, discrediting himself by his deposition before the court. And such contradictions are there not minor in nature, they are major. When a witness shakes the very foundation of the prosecution story, when a witness shakes the very theory of his being present on the spot when the incident took place, then his contradictions are treated to be major in nature. When he says, yes, I had seen the incident, but there was complete darkness of night, there was no source of light, he was not even familiar with the height and voice of the assailant and the injured, he was not a neighboring person, he was from a far, far away person, he was not familiar with either side, either with the injured or with the eyewitnesses or with the assailants. And he says, yes, still I had, for my guesswork, made up my mind that assailant XYZ had assaulted the deceased. No, he has to be disbelieved because though he might be present on this spot, but due to darkness, he had seen nothing. He had neither seen the injured, who was the injured, who had caused those injuries. He had not, could not be able to identify the accused persons nor the injured person. So despite being on the spot, this testimony is a waste testimony. It has to be rejected. When contradictions of the nature are there in the oral evidence of a witness, which led the court to form an opinion, the witness is not believable, then contradictions are treated to be major. And when a witness tells only some minor things which do not erode his credibility, then he is treated to be credible. I am giving you one example. Minor contradictions. A person gives 2 blows with a stick to another. In medical legal examination, certain contusions were recorded. 2 contusions were recorded. And doctor has opined these injuries were caused by hard blunt object. Means stick, some hard thing. When this witness comes to the court and he is examined as eyewitness and subjected to cross-examination by the defense counsel, the witness says, the question is put to him, how long this incident continued? What was the duration of this incident? Half an hour, 10 minutes, 5 minutes? How many blows accused persons had given to the injured person? Witness says that accused persons were holding sticks into their hands and they had given hand converted into injuries. All the part of body was hit. Says yes. And medical report says no, only 2 contusion injuries on the back of the injured were found by the doctor during medical examination. And this man says more than 100 sticks, 100 blows were given by the stick by the accused. And all the blows, all the injuries were being received by the injured. According to the deposition of this witness, the injured should have sustained at least 150, more than 100 injuries, but the doctor has recorded only 2 injuries. How will you deal with this contradictory version? Witness claims to be eyewitness. He says the accused was holding a stick. Doctor says hard blunt object injuries were sustained by the injured and they are 2 in number. It means only 2 blows were given. This witness says more than 100 blows were given. Will this witness be disbelieved? Answer is no, because Supreme Court says it is human nature to exaggerate, to put the things in exaggerated version, hyperbole version. It's a very human nature. So when somebody tells some exaggerated version, false version, because of nature of human weaknesses of human nature, so then courts are okay, system is okay. Witness will be believed. Exaggerated version would be ignored. Yes, people are habitual of mixing some truths with untruths. But how will this witness be judged by court? The witness claims to be an eyewitness, to be present on the spot. He says the accused was carrying a stick into his hands. Doctor says yes, hard blunt object injury was caused to the injured. Then where the witness has told the lies? Oh, here he's saying about a weapon which finds support from the medical opinion, hard blunt object, the stick. Only difference is in the number of blows, number of injuries caused to the injured. Here Supreme Court says this is okay. Court should not give unnecessarily undue importance to the statement of the witness that 100 blows were given and all the injuries were being received by the the injured, which do not match with the doctor's opinion. Because holding stick by the accused is supported by the witness. Law is that such a witness has to be believed. Witness has here mistaken about the number of injuries caused to the injured. This is not a ground. If he says, if this witness had told to the court, no, accused was not carrying a stick, but a knife, but an axe, but a firearm, and he has fired at the deceased, at the injured, and had caused him injuries with the firearm, with the sharp edge cutting weapon. So then this witness would have been disbelieved. But he has not mistaken about the nature of weapon. And incident ended in 2 minutes, 5 minutes, and in cross-examination, this witness says, no, incident continued to occur for hours, for half an hour, for 2 hours. Again, this statement will not be given any undue importance, because again here this witness is exaggerating. He is mixing truth with untruth. Embellishment. It is called in legal term embellishment. Mixing truth with untruth, making a false statement and at the same time making a correct statement, true statement. Mixing truth with untruth is called embellishment. When there is embellishment, when there is exaggeration, inconsistent statement, somewhere this witness says 10 sticks, blows of 10 sticks were given to him, and somewhere says no, 50 blows had been given. It doesn't mean he is lying. He is just exaggerating. He is just mixing truth with untruth, and this is okay in our system. So long as the appearance, the presence of the witness on the spot is not disbelieved, so long as the saying of the incident by the witness is not disbelieved, normally the deposition, the oral evidence of the witness has to be accepted by the normally lies he will be believed. So court is not bound always court will believe and will not disbelieve the witness. But normally, if there are no major contradictions, no major factors, negative factors, infirmities, weaknesses in the deposition of the witness has to be believed. I just took you to this principle, this formula, which the Supreme Court has evolved over the years to judge the credibility of a witness, to hold whether the witness is reliable or unreliable, and if reliable, to what extent, and if not reliable, then to what extent. I had taken the oral evidence of an eyewitness. I tried to explain to you how you will test the credibility of the witness, what are the formulas which you will apply to test the credibility of the oral evidence of the witness. I'm again repeating, formulas are contradictions, inconsistencies, embellishments, exaggeration. One more point. Suppose there are more than one eyewitnesses before a court incident took place, and there were 3 witnesses, PW1, PW2, PW. These 3 PWs are called and examined before the court by prosecution. One witness says he blow to the injured was given with a stick, other one says with knife, other one says firearm. These 3 witnesses claim to be eyewitnesses, and they have given 3 different versions of the weapon, of the manner of occurrence. How will, as court, as judge, you decide which witness is reliable and which are not reliable? Here you will apply the principle what is other evidence on record. If there is some other evidence on record which suggests that the blow was given with hard blunt object like stick, then PW1 who had deposed before the court, the accused was holding a stick and he had hit the injured with the stick, his oral evidence will be accepted by the court. And those remaining 2 PWs, PW2 and PW3, who had stated the accused was carrying knife and had given a blow with the knife to the injured, his statement doesn't find any support from the other evidence, that is medical evidence on record. This PW2 has to be disbelieved. Then PW3 says no, firearm was used and injury was caused to the injured, but the medical evidence on record shows no firearm injury was caused to the injured person, rather he was hit by some hard blunt object which PW1 had told. So this PW3 will also be disbelieved. So these are certain methods which are applied by courts in judging the testimony of. Then section 161, 164 of the CRPC. When investigation of the offences starts, the investigating officer records the statements of all those witnesses, all those persons who are somehow connected with the incident. If they are eyewitnesses, if they have played any other role in the entire process, their statement is recorded under 164. And if he takes the witness to the magistrate, then magistrate records their statement under 164. These statements are not substantive pieces of evidence. The statement of a witness recorded by police under 161 is not admissible piece of evidence. It is not evidence. It is just former state. It is is used only under section 145 or 157 of the Evidence Act. There are two sections in evidence, 161, 164. Former statement. Former statement of that witness is used to contradict him if he has appeared before the court and has deposed. Under section 157, his former statement recorded under section 161 may be used to support him, corroborate him. If contrary to his previous statement made to the IO under 161, he has made a different statement to the court when he appeared before the court, then a contradiction will appear. There are two contrary statements on same very fact, then witness will be disbelieved on this point, on that fact. But if the witness has deposed before the court the same very facts which he had stated to the IO under section 161 during investigation, then his statement before the court is finding support from his previous statement that was recorded by the IO under 161. That statement will then help him. He stands corroborated under section 157 of the Evidence Act, and he has to be believed. And who has contradicted in his two statements, then he has to be disbelieved on that fact. So these are certain methods which are applied to decide the credibility or incredibility of the witnesses. Let me again point out one thing to you. If different witnesses make different statements, just I pointed out, BW1 says the accused had given blows with the stick, other one with knife, third one witness had spoken about firearm. One witness cannot be responsible for the misstatement of other one. Every witness has to be judged on the basis of his present and former statement. In most of criminal trials, takes which lawyers appearing for the defense commit is that they use the statement of some other witness to contradict some other witness. This is not the scope of section 145 of the Evidence Act and 157 of the Evidence Act. The difference should be in between the two contrary statements of the same very witness. Statements of two witnesses, two different witnesses cannot be compared to elicit contradiction under section 145 or to elicit corroboration under section 157. It's another matter if the two witnesses are deposing to the court the same thing. Obviously, the testimony of each of them will find support from the testimony of other one. But if a particular witness says something to the court and court believes it, so then this witness cannot be disbelieved with reference to the statement of any other, because no person can be held responsible for any misstatement, wrong statement made by him to the court or to somebody. A person is responsible only for his statement. The testimony of individual witnesses has to be judged based upon the quality of their own testimony, the reference to their former and present statement. This comparison theory is a mistaken theory. This is beyond the scope of section 145. And most of the time in a criminal trial during the course of argument, the defense counsel does the same. He compares the one line having appeared in the statement of one witness and then compares it to the statement of some other witness recorded at the trial. This is never a scope of section 145. I'm again and again impressing upon your mind. Please, whenever a contradiction is sought and impressed before you, if you are a judge or magistrate, you must keep it in your mind. No, this is not the scope of 145. You can refer to contrary statements of the same very witness. If you are an arguing counsel, a defense counsel before a court, arguing in a criminal trial, you must see it, whether you are seeking contradiction, you are trying to show the contradiction in between the two contrary statements of the same very witness or in between the two contrary different witnesses. So this is the position. A former statement or present statement of any other witness cannot be used to discredit some other witness. The statement of the same very witness. One former, another present. Present means that was made to the court. Third, I tried to explain to you the method given in law, how the witnesses are impeached, how their credibility is questioned, and how the courts deal with the issues of credibility and incredibility of the oral evidence of witnesses. If you have any questions, any doubts, queries in relation to what I told you so far, please feel free to put your query. After dealing with your queries, answering your questions, I will take a few more points. Please ask questions.
So a participant wants to know, is a plotted witness same as a tutored witness? If not, what is the difference?
Tutored witness, right?
Plotted.
Right. Planted witness and tutored witness. What is tutoring? When a person knows nothing about a fact, but he knows about such fact only from the knowledge of others because of being tutored, because of being told repeatedly by others. When a person did not know about a particular fact on his own, he had neither seen the incident taking place, nor he had on his own heard that person saying something, who has neither seen nor heard, but he is deposing before the court, and evidence has been brought on record that he was told, tutored by someone else. So when a person borrows his knowledge about certain occurrence, certain incident, or certain fact from the knowledge of others, then he is said to be a tutored witness. But if the witness himself knew about that fact, that incident, means he was present on the spot when the incident had occurred, he had seen the incident occurring, and somebody then told him, other witnesses, the police wala or the counsel engaged for the prosecution, or the public prosecutor himself tutored him, told him about those facts. So this tutoring will not be treated to be a discrediting fact, because the evidence is that witness has deposed that he was present on the spot, he had seen, and otherwise also, suppose there is a CCTV camera, the witness can be located in the visuals recorded by the CCTV camera. He is present on the spot when the incident took place. He is very much visible. This fact is established because of this electronic evidence on record that he was present on the spot when the incident took place. And the witness has admitted during cross-examination that when I came to the court today, then the public prosecutor tutored me, read over the version contained in the FIR, and asked me to depose in support of the prosecution. This statement is there on record from the witness. Still, witness will be believed. Tutoring will fail. The tutoring theory will fail because the witness was seen present on the spot at the time of occurrence, and the electronic evidence available in the form of CCTV camera in his presence. So, tutoring, when a person himself knows about a fact, then tutoring apart, he has to be believed. But if evidence is that the witness could tell to the court about the manner of occurrence or about the facts relating to the case only because of tutoring, he had no personal knowledge, then tutoring will go adverse to the witness and he will be disbelieved. His oral evidence would be rejected. So then what is the test? If the witness had personal knowledge of that fact about which he deposed before the court, and then he was tutored by someone, then tutoring doesn't matter. Despite tutoring, testimony of witness should be accepted. But if the case is this, that witness was not present, he had not seen, he had no personal knowledge of the fact, but for the tutoring, then tutoring will be a very, very serious negative factor. This will go to the root of the oral evidence of the witness and he will be disbelieved. This is tutoring. There are host of cases. If the participants are able to see my write-up available on my website lawhelpline.in, so tutoring is a point. TUTOR type करके दिखाओ. I'm citing a Supreme Court case. You can note for your knowledge. Otherwise, if it is there, you can consult it. You can open this website on your TUTOR. The Supreme Court has clarified the position of tutoring. It is here point number 8.1, para number 8.1 my write-up. Supreme Court says if the witnesses knew that fact out of their own knowledge, it is immaterial somebody tutored them of the same very fact. Tutoring or no tutoring, they had already their personal knowledge about that fact, and that case is Maksudan versus State of Uttar Pradesh. You want to note down Maksudan, State of Uttar Pradesh, 1983, 1 SCC, Balu Mohan, Supreme Court cases 218, 3 judge bench. 1983, 1 SCC, 218, 3 judge bench. And another point was after tutoring, which point, which witness you had? Hello.
So the next question is, if a witness was present when the crime occurred and in the court he says that he was absent, then is there any punishment for him?
Then such a witness is completely hostile witness under Section 154 of the Evidence Act, where he demolishes the very case of the prosecution. If in examination in chief he says that I was present on the spot when the incident took place and I had seen the incident, and in cross examination he says no, I was not present, it means that he is contradicting his very presence on the spot. This is not a minor contradiction, it's a very, very major contradiction, serious contradiction. And when a witness was not present on the spot, there is no question of saying something by him. He witnessed nothing when he was not present on the spot. You know, a witness could have seen something only when he was present on the spot. Otherwise, if he was not there, how could he see every deposition, every statement made to the court by him, just a false statement? He has to be disbelieved. For this false statement, he can be prosecuted if the court records a finding in its judgment that the witness has lied. He has given false evidence before the court. Then Indian Penal Code section 193, perjury, giving false evidence by the witness. It is punishable offense, cognizable, non-bailable, punishable offense, and this offense was committed during the pendency of the judicial proceeding before the court. Therefore, witness can be proceeded against under section 340 of the CRPC. Analogous new section in Bhartiya Nagrik Suraksha Samhita would be different. You can see it for you in this new BNSS 2023. In CRPC, there was section 340. He can be prosecuted. Court would file a complaint in the competent court of my state, or there is another section 344. If the court recording the finding in the judgment is a court of sessions or a court of judicial magistrate first class, and if they have recorded a finding that the witness has deposed falsely, then need not to file a complaint, a court complaint under section 340 in the ministerial court. This court itself can then proceed under section 344 in a summary manner. May issue a so-called notice under section 344, may get him prosecuted, may get him punished, and award the penalty provided in section 344 for the offense of perjury under 193. When a witness lies for the court and a finding, and unless a finding is given by the court, witness cannot. There must be a finding in the judgment by the court that the witness had given false. Then he can be prosecuted. Provisions are section 340 CRPC or alternatively 44. More questions?
Sir, how is forensic evidence examined by the court, and what are the challenges faced by courts in evaluating digital evidence?
I had told you that I will be covering this subject because it's a very vast subject.
Yes, sir.
I had deal with this entire electronic evidence next session, including this forensic. But if you are raising
So
this
we will cover
question
this in the
today,
next session. You
just
can address it then.
no problem, no problem. I'm just coming to this. Otherwise,
Yes.
I could have taken it. What is first point?
How is forensic evidence evaluated by the court?
Right. In forensic sciences, many things are covered. At one time, there might be some forensic report on poisoning. If a person has died because of poisoning, so obviously on preservation of viscera and on its examination at the forensic laboratory, a report would be placed before the court. And what poison? Poison. In a forensic laboratory, when a suspected case of poisoning, viscera or any other poison is sent, then it is examined. Suppose ki DNA has to be matched, section 164A, 53A of the outgone CRPC, which is still applicable in the cases which were pending in the court up to June 30. Do you know DNA will be matched in the case of rape, sexual offences, and a report for forensic laboratory will come. Unless there is any contrary evidence on record to lead the court to form any different opinion, an expert's opinion would be accepted. But expert's opinion, whether he is a forensic expert or any other expert, alone in itself is never final. Court can reject it because no expert is above the court, above the judge. If any other evidence on record supports the same thing, same finding which the forensic expert is saying, then forensic expert's report would be accepted. But if other evidence, credible evidence on record leads the court to a different conclusion than what the forensic expert has opined, then forensic expert's report would be rejected. Because like any other expert, no expert is ever final, conclusive, binding upon court. It is the court which has to evaluate the expert's opinion, whether it is a forensic expert, ballistic expert, a medical expert, or expert like handwriting expert, thumb impression expert. Number of experts are there, but none of them is binding upon the court. If the other evidence on record supports the opinion of the expert, it has to be. So is here in the forensic expert's case. His opinion is supported by other evidence on record. Okay, it has to be accepted. If other evidence is found to be credible by the court, but the expert evidence has stated to the contrary, then expert will be rejected. The credible other evidence on record would be accepted. This is the law about all types of experts, whether they are forensic expert or any other experts. I am showing you a few cases of the Supreme Court 2024. Hari Prasad versus State of Chhattisgarh. Only this year Supreme Court ruled in a poisoning case ki It's never binding. If simply because the forensic expert has reported that the deceased had died out of poison, it's not conclusive for holding the accused guilty, because there are certain other conditions also. They are whether it was the accused who had administered the poison. If this is not proved, then even if somebody has died because of poisoning, how can accused be held liable for it? There must be evidence it is this accused Mr. X who had administered the poison. If this fact is not proved, so simply because of post-mortem report or forensic expert's report about death due to poisoning, accused will not be convicted. He will be set free, acquitted. Like any other expert's report, forensic expert's report is also never binding upon court. It depends upon other evidence. The court accepts other evidence, and same thing is also told to the court by the expert, then it will be otherwise not. Other questions?
Oh, no, sir, not for now. We can move
I
on.
think we covered how much time?
Yes, sir.
We should now conclude. Ask
Okay.
someone to put some more questions.
Okay, sir. So we are participants will be concluding. So you all can ask your queries directly. Also, you can ask, sir.
If somebody has some more questions.
Sir, a participant is asking, is there any limit on the number of witnesses that can be examined?
Right. No, not at all. So, SOLE, type word SOLE. Section 134 of the Evidence Act says, in no particular number of witnesses should be required to prove any particular facts. In our criminal jurisprudence, it is not the quantity of evidence that matters. It is always quality of evidence that matters. If a single witness has been able to prove the prosecution case beyond a reasonable doubt to the satisfaction of the court would record the conviction of the accused, despite the fact that all other witnesses who claim to be eyewitnesses did not support the prosecution story. Because this is the mandate of law. I am drawing your attention to para 3.1 of my write-up. Sole witness. Section 134 Evidence Act. The bare provision of this section says the particular number of witnesses is immaterial. Then what is material? The quality of their evidence. I am giving you one example. Suppose a riot took place wherein 100 people were injured. All these 100 people who had sustained injuries were made witnesses by the police. 99 witnesses came to the court, gave their oral evidence, and did not support the prosecution case. These 99 witnesses told to the court that though they sustained the injuries during the riot, but they could not identify the assailants, the accused persons. And they say, I cannot say with certainty that the accused persons who are present in the court, they were those people who had caused us injuries in the riot. It means that these 99 prosecution witnesses are not supporting the prosecution story. They have rather turned hostile. But there is one witness, last witness, number 100. He comes and he says, yes, I had sustained these injuries, which are recorded in medical legal injury report, because of being hit by these people who are standing in the courtroom as accused. I identify them. These were the people who had caused me the injuries. And there is no major contradiction, embellishment, exaggerations, etc. to discredit this witness on parameters of those formulas which are applied to test the credibility of a witness. This last witness, number 100, is found to be intact, credible. The result would be conviction. It is another matter. Against this single witness, 99 witnesses have told some other story. They will be disbelieved. This single witness is sufficient for recording the conviction. Why it is so? Because the law mandates so. This is what the Supreme Court says. I am inviting your attention to the Supreme Court judgments on this point. Khema versus State of UP 2023, volume 10, Supreme Court cases 451. Again 2023, Javed Saukat Ali Qureshi. Then Rao Sahab versus State of Karnataka 2023, larger bench, 3-judge bench, 2020, 2016, 2015. A number of cases I have given here under this caption. And this is the law, that it is not the number of witnesses that matters. It is the quality of evidence, credibility of the witness that matters. If a single witness is found to be credible and out of his evidence the prosecution story is proved, then conviction would be the result, despite the fact all other eyewitnesses had turned hostile. So this is the position of.
Sir, next question. Under the new law, what is the process for recording dying declaration?
Oh, right. It can be recorded even by audio video system. It can be recorded by any mode. Need not key. It should be only in writing, reduced to writing. Any electronic device, this mobile or whatever method is there, CCTV camera, even verbal dying declaration can be made. Earlier, the same was the position. Even there was no compulsion in law for the maker of the dying declaration to make it only to the doctor, to make it only to my state. No, even in the presence of a constable, a nursing staff, or a private person, dying declaration could have been made. The same is the position today. Parliament has not changed anything, except electronic devices may also be.
So the next question, what are the provisions relating to admissions and confessions under the new law?
Admissions and confessions can be made even on electronic devices. I had initially clarified to you that there is no fundamental change. There is no major change in the Evidence Act in this new Bhartiya Sakshya Adhiniyam. Only cosmetic superficial changes. I will not say superficial changes. I must say those changes which have not affected the original provisions fundamentally, drastically, substantively. So earlier also, through any mode, confession could have been made. If it is a judicial confession, you know, it has to be made either before a judicial magistrate. In the old CRPC under section 164, warning will be given. And if after warning, he still shows his willingness, no, he voluntarily confesses the guilt, he is not under duress nor under threat from police wala. In such cases, the cautions and precautions were that when he is produced before the court to make confession, the procedure was he should normally be kept for 1 day or 2 days, 3 days in jail, in judicial custody. Then he should be called to the court and should be warned, should be informed and warned by the magistrate. If he makes a confession, this confession may be recorded and he can be convicted for this offense on account of this confession made by, and that he is not bound to make the confession. Same is the position even today. One more thing has been added: confession can be made on electronic devices, mobile, or any other recording audio video system, electronic system, and that will be also admissible. If he makes the confessional statement during the course of inquiry or trial before the court, that's very much judicial confession. It can be recorded. He can be convicted by the court because he made the confession to the court during inquiry or trial. The same as the law earlier, same is the law even today. Only difference is the electronic devices are now allowed, used for recording. Other questions?
Good evening, sir.
Yes.
I am very much grateful for your lucid and very informative with all nuances you have explained changes. Here, I would like to know where are the other single judgment or list of judgments wherein it is stated that the expert opinion, including medical opinion, can be kept aside, can be ignored, need not be taken into consideration in the light of other evidences, including ocular evidences.
Which expert? What expert? Expert of which subject?
Sir, medical expert बोल रहे हैं वो.
Even medical expert, doctor's opinion is also not conclusive. Court, always keep one thing in your mind: opinion furnished by any type of expert is never binding upon court. Court may or may not accept his opinion. Question should be asked when court will act upon the opinion, when court will accept the opinion of the expert, and when court will not. So answer is, if there is other evidence on record which also supports the opinion of the expert, then expert's opinion would be accepted. And if the other credible evidence, reliable evidence on record does not support the opinion of the expert, then expert's opinion has to be rejected, whether he is a medical expert, ballistic expert, forensic sciences expert, or expert in any other field. Only expert's opinion is never conclusive, even if he is a doctor. Suppose
Yes, sir. Agreed. I want to know the judgments, sir.
Very important case I'm pointing out. Haman Kumar versus THAMAN. Haman Kumar versus State and City of Delhi, 2003 Supreme Court. A very beautiful case from Supreme Court. There in Supreme Court has said, no, whether it is a medical expert or any other expert, his testimony cannot be believed then when the ocular credible evidence leads the court to some different conclusion. Suppose eyewitnesses claim that deceased was fired at, and they are consistent in their statement and supported by some other witnesses also. The doctor says, deceased had died because of this, strangulation, throttling. There are cases where some person sustains injury, he is brought to the hospital for medical treatment and for medical legal examination of his injury. And suppose that during the course of treatment he dies, then his dead body is taken to the mortuary for autopsy. And there is difference between the testimony of two doctors. One says some story, other says some story. And third story is told to the court by the ocular witnesses, eyewitnesses. And the court is of the view, after testing the oral evidence of the ocular witnesses, that yes, witnesses are credible, reliable. Then witnesses will be believed. Improbable opinion given by the medical expert or any other expert would be rejected. This is the case which I am pointing out to you. Thaman Kumar, State Union Territory of Chandigarh, 2003, 6 SCC 308. Number of cases are here where doctors have been disbelieved because the doctor's theory, you know, many a times doctors suggest ki, yes, this injury could have been caused to the injured because of falling from a tree, from height, from building. Ordinary injuries, simple injury cases, the suggestion is given to the doctors during their cross-examination. Please, doctor, tell whether the injured could have sustained these injuries because of falling from height. He says, yes, yes, yes. And the eyewitness says, no, he was hit by iron rod or this or that, some blunt object, and then the injured has sustained the injury. Now the argument from the side of the defense should be placed before the court. Honorable court, look here. The doctor has suggested in his deposition that such injuries could have been caused to the injured because of having fallen from height, from roof of the house or from a tree, from some other place, high place, and it had not caused him any injury. So whether because the doctor has deposed like that in his oral evidence would be believed by court? No, not at all. Doctor, this statement of the doctor would be rejected, disbelieved, because the nature of injury which the injured has sustained, it is not denied by doctor. Doesn't say no, such injury was not caused to him. Injury is recorded in medical legal report, and the witness, eyewitness, is saying, I had seen with iron rod accused had hit at the injured. Here, ocular testimony of eyewitness would be believed. This statement, contrary statement of the doctor, would be disbelieved. So this is the principle. If the version, if the testimony of the medical expert is so improbable, which does not match with the credible testimony of the eyewitness, then only ocular testimony would be accepted, not of the medical experts. You can see many cases, at least 50 cases I have given on this point in my write-up on this subject. More questions?
Okay. No, sir. Thank you so much, sir, for such a wonderful session. Thank you, sir.